litigator. So he's not just a guy that knows the law, he practices it to the extreme. Because that's the difference between book smart and street smart. And John is here in this position, you know, because he's got that street smart. And hopefully today in our conversation, we'll get some of that from him, not just interpretations of the law. What I'm most keen on also is understanding John's analysis of some of the tactical aspects of this thing as it plays out. So without further ado, I'm going to ask the first question of John, who's our superhero, right? In this superhero saga. You know, if Ripple is Batman, John is Robin, right? If Ripple is Luke Skywalker, he's Han Solo. He's the guy that is going to make the superhero thrive and survive, because without him, there ain't no movie. So, John, 2 days ago, all of us, right, had to read through this painful development of the SEC basically declaring its intent to attempt an interlocutory appeal. One of the things that really struck me was the massive confusion about this. I mean, last night I had a call with a very, very seasoned VC who completely misunderstood that. And this guy was telling me that they had filed an appeal. And I was trying to explain to him, no, they haven't. They've telegraphed their intent, but it's still subject to a whole bunch of different things. There is no appeal yet, and there may not be. So could you kind of walk us through all of that and clarify the actual legal situation?
Yes, Joe, and thank you so much for the kind words. I appreciate them sincerely. Listen, I saw this coming because, in fact, I just tweeted before we went live, because Charlie Gasparino tweeted out an article on that FX Street did, saying that the appeal was granted, right? And so and I knew that was coming. And all that happened is, and I can give you the perfect example. All that happened was the SEC filed a pre-motion letter. And the rules of the Southern District of New York Court, you can't just file a motion. You have to ask the judge, hey, I want to file a motion, a formal motion. Will you allow me to do that? It's like a preliminary request. I had to do the same thing when I filed a motion to intervene. I had to write a 4-page letter to the judge that said, hey, judge, I want to do something that's really never been done. I want to file a motion to intervene on behalf of tens of thousands of XRP holders to be named defendants in this case. And a lot of the securities people out there say, oh, that'll never happen. She'll never allow him to do that. And she did. And then she denied that motion, but made me amicus counsel. So the point I'm bringing is that I predicted that she was going to allow the SEC to write a formal motion so then she could respond to it, right? She's not going to just flat out deny them the opportunity. That itself could create some kind of issue. So she said, fine, you want to write a 25-page memo asking me for an early appeal, go ahead. And then Ripple will respond to it, and then I'll give a decision. I expect her, and I could always be wrong, but I expect her to deny the actual appeal request. But in an interlocutory appeal, even if Judge Torres said, okay, I'll let you make the appeal, the SEC then has to ask permission from the Second Circuit Court of Appeals.
Told y'all.
And they could say no. They could say, no, we want to hear all issues once all of the trials are done and all the evidence is done. And so what's going to happen, Joe, is we're going to get the SEC's brief, I think it's today, where they file it. Then Ripple will reply next week or oppose it, and then the SEC will get a reply, and then the judge will rule. And I expect her to then say, look, this is why you don't get an early appeal denied. And then we go on and they deny the stay that's been requested, and the SEC would have to wait until after the trial before a jury of the two executives. So And then that's not until the summer of next year. And so the good news is once the judge denies this request for appeal formally, it's going to be a couple years before it would ever go before the appellate court, before we would get a decision. Personally, I believe the appellate court is going to absolutely affirm Judge Torres, and XRP is going to continue to have the clarity that it has. I mean, everyone needs to know this. Think about how fast Coinbase relisted XRP. Kraken, Gemini now has listed XRP. They would not have done that if there wasn't confidence.
Everybody share this
that
live
the
now,
Torres
please.
decision is going to stand the test of time.
Yeah. And by the same token, I think the reason why the SEC's had to come out with guns blazing and with wild-eyed desperation almost with this appeal thing is precisely because Judge Torres's opinion on the very specific issue of whether XRP constitutes security was so crystal clear in its application of Howey, without trying to extend its legal interpretation, but just taking the actual sort of words and meaning of Howey as it, as it's been reflected, right, in precedents, and applying that it becomes very difficult now for the SEC to take certain of the actions it wants to against Coinbase and against Binance and all these other guys on their target list. So all of a sudden they're saying, oh my gosh, our whole plan to go after all these guys and basically burn the whole landscape down may not necessarily work anymore. We got to figure out a way to reverse that decision, that judgment.
Well, you're 100% right. And what people need to know is that Judge Torres did exactly what the SEC said and requested. The SEC said, here are different categories of sales. There's institutional investor sales, there's programmatic sales on exchanges, and then there was some XRP given to employees or independent contractors who didn't pay for it, but just was sort of given to them. And we believe each one of those categories violate the law. And so all the judge did, and remember now, Gary Gensler and the SEC has said for years now, it's very simple. It's very simple. The clarity is, we've given clarity. Howey is the clarity. Howey is the test.
Yeah.
So the judge then took their different cells that they segregated and applied the test to each one of those cells with the evidence, and then she came out. Now, did some people say, well, wait a minute, that doesn't make sense, Joe, because institutional investors are accredited and they were determined to be securities transactions, but the unaccredited investors on the exchanges are not. Aren't the securities laws meant to protect the unaccredited versus the accredited? And the answer to that is that's not the Howey test. The judge applied the Howey test. That's what happens, Joe, when you take an 80-year-old test that tries to stuff orange groves, right, and try to pigeonhole it into modern-day blockchain technology. Wait till we get to artificial intelligence technology and any other technology thereafter. So that's what happens. And Judge Torres, her job is not to say, well, wait a minute, what is the policy considerations in the 1930s? Does my result of the Howey test, and when I apply it objectively and fairly, does it comport with policy considerations from 80 years ago? That would be improper. There is no Howey factor that says what level of education or sophistication does the investors has. And so very confident. Listen, one thing I did right in this is I predicted that this was going to happen. I was on Fox Business and I said this was going to happen and Ripple might not get a complete victory. And Judge Torres did her job. She did it effectively. And I don't believe it's going to get touched on appeal.
Hey, John.
If I could just ask one more final question. So assuming that she says, you guys can go ahead and file that 4 or 5 page, whatever motion, I'll consider it, and then ends up after reviewing that and also reviewing Ripple's response, obviously decides to say, nah, you can't do an appeal at this stage. It's premature for all these legal reasons. You have to go to trial first, right? So they go to trial. What does that time frame look like for the trial and the final outcome in your best judgment? And second, who actually goes to trial and for what, right? I mean, is it Ripple and the two individual defendants? Is it just the two individual defendants?
Great question, Joe. It's just the two individual defendants. The Judge Torres decided that as a matter of law, that Ripple's sales to the institutional buyers were investment contracts. But she said, whether or not the two executives meet the recklessness standard, that's for a jury to decide. She said, it could be a very tough, standard for the SEC to meet. I don't think they can meet it, but that's for a jury to decide. It's not for the judge to decide. And so it would just be the two investors, executives, Brad Garlinghouse, Chris Larson, and the issue before the jury. And this would be next year, the summer of 2024. And a trial, just so you know, it would be, I kind of, being a litigator, would like to see it. I know that, Brad and Chris might have different, I think they'd like it, to be honest with you, in some ways, because, that allows them to call Bill Hinman as a witness, for example. It allows other people to testify. And the issue would be, was Brad Garlinghouse and Chris Larson reckless in not knowing that XRP was a security? So just think of all the evidence that will be presented. Like, for example, SEC enforcement lawyers were not prohibited from owning XRP at the same time that they're claiming Brad and Chris were reckless in not knowing XRP is a security. That's just one piece of evidence. And there'd be lots of more evidence, but a trial would take, weeks. And then there would be a jury verdict. I would anticipate the SEC would lose that case. No experienced trial attorney can ever predict what any particular jury is going to do. But I can tell you this, the SEC doesn't want to try the case. In fact, in their papers that they just submitted, Joe, they've already hinted that they would drop the charges against the experts if the judge allows their appeal to go forward. That shows you how confident they are.
Wow. Yeah. That's a very good point. So at the end of the day, for Ripple as a company, setting aside those two individuals, and for that class of XRP issuance that was deemed to be securities offerings, meaning their initial placements to, accredited institutions, right? How does that all get settled up?
Well, this is the thing, and Ripple made it clear that they object to an early appeal because it's more appropriate to wait until all issues go before the appellate courts instead of piecemealing the appeals. And the reason, just for your audience, the reason why I'm confident that she will deny the appeal is because when you do an interlocutory appeal, it really is supposed to only pertain when there's only an issue of law, only, and that there's no facts for. But here, Judge Torres applied facts. She cited the XRP holder affidavit. She cited all kinds of other evidence. And so it's not right for an interlocutory appeal because the Second Circuit would have to evaluate the factual record, which is, of course, millions of pages. And so that's why I brought out the fact that the appellate court, even if Judge Torres agreed, might say, no, we don't want to deal with that now. We want to deal with an all issues appeal when everything's over. Because think about this, if there was an interlocutory appeal, it would be on these issues. And then there would be a trial. And then there would be on, more appeals later down the road on those issues. There could be even a second interlocutory appeal after the first interlocutory appeal. Now, why do I explain that? This is the other reason that people are that they miss, Joe. If you look at the footnotes in Judge Torres's ruling, she did something brilliant, right? She simply said, look, with programmatic sales, when I apply the third factor of the Howey test, there is no evidence that people who were buying on exchanges were relying on the efforts of Ripple. Ripple didn't know who they were. They didn't know they were buying from Ripple. There's no promises to rely on. There's no evidence presented. So she said, therefore, the Howey test is not satisfied. Then you look at the footnote and she says, I don't reach the common enterprise or the first prong, the investment prong of Howey, or the second factor, the common enterprise, because there's no need for me to do it because they didn't meet the third factor. So if the SEC were to win on appeal, which they won't, but if they did hypothetically, it's not case over. The judge, they would remand it to Judge Torres and say, now apply the other Howey factors to the evidence. She could then turn around and say, well, you didn't meet the common enterprise factor, and then give the same ruling because they didn't meet the common enterprise factor. Then there could be another interlocutory appeal on the common enterprise factor. So if I'm the appellate court or if I'm Judge Torres, I'm like, I'm not dealing with that. Plus, you know what, right? Yeah. Let's deal with it at the end when everything is over. And so that's why I come. I know I got a little bit in the weeds there, but I really want to explain to people why I'm so confident in what I say.
Hey, John, when the judgment originally came out from Judge Torres, I seem to remember that the court forced upon both parties 2 settlement dates to have conversations. Was that the case?
I mean, there's always sort of standard operating procedure is that when there has been a result, even before the result, there'll be what's called mandatory mediation. And then after result, the court institutionally wants to encourage settlements so that we don't have such a backlog, right? Imagine Judge Torres now, she's looking at a multiple week, if not multiple month trial with Brad Garlinghouse and Chris Larson. That was going to tie her courtroom up for weeks and weeks. If she doesn't have that, then she can, tend to other business. And so whenever they can settle, they try to encourage the parties to settle. But, there's going to be, at this point, there's going to be no settlement because the SEC, what Joe said, how can they settle and then go after Coinbase, right? And here's the thing that everyone, linqto and everyone should be so confident about why this was such a huge victory. Let's just be objective. Ripple owns, 45, 50% of the outstanding XRP, right? If when they sell it on an exchange, it's not a security, then how could it ever be a security if Coinbase sells it? Right? Sure. If Kraken sells it, or if you sell it, or if linqto sells it, that's why you saw Coinbase and Kraken and all of them not wasting any time. They're like, well, shit, if it's not a security when Ripple sells it, it can't be a security when I sell it because I don't own all that other XRP. I wasn't involved in the company. It wasn't gifted to me, blah, blah, blah. So that's why it's such a big loss for the SEC.
And to that point, I want to bring up a tweet. So one of the things, and speaking with our members every day, this has been such a long road, as we talked about earlier, and learning the legal process through this, and there's the unknown for the Ripple investors and the XRP investors, which a lot of times are both one and the same. The day after the judge ruled, somebody had tweeted on Twitter, according to summary judgment, our ODL, which is on-demand liquidity, which used to be called XRapid, are ODL-related sales now considered securities? David Schwartz from Ripple answered this, and here's what David said, and I want to share it with everyone that's here on this call because I speak with members every day, and I like to share this, and then I'd like to have your response to how you feel about this, John. So David's response was, and I quote, "We're still figuring this out. We don't currently have ODL related sales with a US nexus, and not being able to do so is not really a huge deal. We can still do ODL in the US so long as XRP is never sourced from Ripple. And before I ask you to respond, I just want to emphasize that the original use case for XRP in a payment stream of using RippleNet was called XRapid, which is now ODL, but it was originally designed where the user would buy and sell their XRP through exchanges and not source it from Ripple at all. What are your feelings? Do you think that financial institutions in the US can use XRP currently, and do you think anybody will do it until the case is completed?
They're already.
Well, I think they're right. Listen, you know, when the first decision came out, I did a live stream, and it was just with a couple hours after the decision. And I said the only thing that I saw was, you know, the judge grouped ODL into institutional sales, and you know, technically they're not investing because they're using it as a bridge currency and all those things, and they don't own it outright. They're not relying on the Ripple of efforts because it's seconds later, they don't have it, blah, blah, blah. And so, you know, no one can ever say a decision is going to be perfect. And so, but I agree with David Schwartz, and that's why I don't think Ripple's that concerned, because as long as Bank of America isn't purchasing it directly from Ripple, they can use it. They can certainly purchase it off Coinbase or Uphold or somewhere like that, and use it how they see fit that way, and then resell it. And so I'm sure there's ways to create, you know, my issue would be, how does Liquidity Hub work if that's a Ripple platform on XRP? I mean, so there are some issues, but the thing about it is there's ways around that makes it workable, even though it on the surface it doesn't make perfect sense. You know what I mean? Like ODL. And that's the only thing that I would have nitpicked Judge Torres about. But I think that Ripple has operated without direct sales in the United States to institutions for the last decade, and they've done quite well. And do I think those institutions will use it? Sure. You know, I think that the number one problem for XRP in the United States was liquidity.
Right.
And liquidity is back. And the better question, I guess, or more relevant question, Nick, is how soon will they use it?
Right.
I think the answer is yes, they will use XRP and utilize it. The question is, will it be in the next 12 months, or will it be, you know, 2 years from now? I don't know.
Do you think because of the continued legal proceedings, they're going to want to wait when they could still use it today? Will some financial institution want to get a jump on other financial institutions for a strategic advantage and try and jump out first? I mean, because at the end of the day, we see a situation where, yes, this legal quagmire continues, but the Ripple net system and the use of ODL can still take place. And the question is, I'm just asking and wondering every day, will somebody step out and do it? Or are they going to wait for this to be completely over?
Well, I would advise them to look at Uphold and the advantage that Uphold had by not delisting XRP, and looking at their growth, looking at their revenue stream of XRP. And so is there some kind of corporate attorney who's so conservative he or she's going to say, well, it's best to wait until all appeals are exhausted? Well, but you could be waiting 7 years, because that would include the Supreme Court. I believe that the smarter ones are going to and take advantage of this law, if you will. I have no doubt it's going to be utilized. Question is, you know, how soon?
Right. That's the big question. Yeah.
I mean, if I'm advising them, then, you know, I'd be like, listen, a year advantage in this market is a huge advantage. We should jump on it.
Yeah. Nick, on this whole issue of ODL and programmatic sales being very, very clearly and just very clearly designated as not being securities transactions, right? So that's the way that going forward you would expect large institutions, financial institutions, certainly like Bank of America, to transact. I think it was actually quite timely and maybe fully intended that Ripple created and introduced this liquidity hub product. Because what I'd be doing if I were in Ripple's shoes today is I'd be integrating a liquidity hub into the RippleNet product. So every user of RippleNet, like Bank of America, report into a liquidity hub as the means of obtaining and managing that XRP position that they need to work through ODL. Right? Liquidity hub is just a massive, smart router engine. It has feeds to accounts that Ripple has opened across all the liquidity venues around the world. Basically, virtually every exchange where there is depth of liquidity, it has accounts at. So if I'm Bank of America, I become a liquidity hub customer, and on any given moment, or where I need, pick a number, $1 billion worth of XRP to transact, I plug that into Liquidity Hub, and Liquidity Hub will break that $1 billion up into fractions and route them for execution and closing across all the exchanges to get the optimal average acquisition price for XRP. And then when I'm done using the XRP for ODL, I turn around and I go the opposite direction, and I have that same smart engine route my sell order and go back to cash. And that's what I want to do. Sell the XRP across all the venues to get the optimal price for Bank of America, right? And at no time do I ever have to be in a position where I'm actually taking XRP from Ripple itself. I'm doing it through all of these exchanges. And what Ripple will do in that instance is it'll be on an ongoing basis looking at the XRP available across all those exchanges worldwide and just distributing XRP through those exchanges. It will sell XRP into those exchanges to create supply.
Yeah, listen, let's say that for whatever reason, Bank of America needed 4 billion XRP. Well, Coinbase simply notifies Ripple they need more XRP. Mm-hmm. It sells it to Coinbase. Coinbase sells it to Bank of America. I mean, that's why I said is I don't see the ODL situation as that bad.
Yeah.
For Ripple, right?
Another point I'd like to make for all of our viewers today, because we have so many new people that have come to the XRP community, that have come to the linqto platform to invest in Ripple, and one of the things that I've seen in the community, and this is just people who speak about it on Twitter, as you do, John, and I have for years and years, and Ripple is out there educating people, is over the last few years, we've gotten away from the basics. And what I learn about a lot of our new Ripple investors is they don't always know the basics of, how RippleNet works. And it is a replacement for Swift. And it's been stated by Brad Garlinghouse that Swift was 94% effective, meaning that 6% of all Swift messages never got delivered. And Brad Garlinghouse used to say for years, what would happen if 6% of your emails didn't get delivered? What would that mean for you and your business? So that Ripple was making that point about RippleNet, which was called something else at the time, but it's RippleNet now, which is on the blockchain. And then the use of XRP is on top of RippleNet, which allows for anyone that's watching, I just want to clarify, the use of XRP allows those financial institutions to not only send the money instantly and settle in 10 seconds or less, and this has always been stated by Ripple, but also allows them to bring home what's called nostro accounts, which nostro means hours in Italian. And those nostro accounts are the pre-funded accounts, for instance, that Bank of America might have in in the 180 countries that they send money to. And what I would love for our viewers to know is there's a huge incentive for these financial institutions to get into gear and use ODL, because they'll be able to take all those pre-funded accounts, take all that dormant capital, as Ripple has explained over the years, and they've used numbers between 10 trillion and $27 trillion in dormant capital that financial institutions can bring home. And that means a lot to these financial institutions. So for anyone that didn't know the Nostro piece of the puzzle to this thing, this is bigger than you may have even imagined. And these banks really want to bring that money back home. So I just want to make that point, because when I speak to people every day, they have no idea that that's one of the big benefits of using ODL.
Let me add this. When those banks bring home all that money, whatever trillion or billions that you're talking about, and they have that much more liquidity, what they do with it? They give more loans. They give more loans to small businesses. They give more loans to individuals because they have the capital, and that moves, the economy outright. So I'm just saying it's almost tragic that it's 2023 pushing 2024 and we're still operating. I would encourage any of the new people to the community to do a wire transfer today. It still takes 5 days for me to do a wire transfer from one account to another sometimes. I did a domestic wire transfer to a client on a settlement that came in, and it was domestic, and it took 4 business days for it to end up in her account, right? So that's kind of obscene when you think about it.
Yeah. Imagine the irony for us, John, that our members wire us funds to invest in a company that can have settlement in 10 seconds or less.
Right.
That's never lost on anyone every day, for sure.
Yeah. You guys are, touching on one of the fundamental elements of blockchain technology that makes it superior for these kinds of financial systems applications, which is that when you're operating on blockchains, you don't need to have a trust relationship with your counterparty, because of the ability on those blockchains to exchange value through what's called atomic settlements, where cryptographically you can ensure that both sides of a transaction have the asset they say they have and have the capability to make that exchange without any doubt, and then have that exchange happen instantaneously and atomically meaning that it's not one party sending to one party first and then the other party confirming they've received it and then sending the other part of the transaction. It happens simultaneously in an instant, right? In the non-blockchain world, you need trusted intermediaries because there is no such thing as an atomic settlement. So there is that risk that if I send Nick the money for the XRP that he says he's going to send to me, he might not actually have the XRP. I don't know, right? And then I'm out the money I sent. On the other side, he's saying, well, why should I send you the XRP first? I don't know you're going to send me the money, right? So the way you solve that in the traditional world is you have something in between called a bank. And the bank basically guarantees that Nick is good for the XRP he says he has, and I'm good for the cash I say I have, right? And they take a slice of that transaction. Yeah. Sometimes that's a huge slice. And so it's eliminating that intermediary function by a trusted intermediary. And that has significant implications. It makes it cheaper and faster and easier for Nick and me to transact. But guess what? It puts that intermediary out of business. And that's the reason why this transition isn't happening fast. Because the guys that are in the business of intermediating need to figure out how to get into that new world and still have a relevant role and still be able to generate money for their shareholders, right?
Joe, I would tell you, some would argue that why we've been waiting in litigation for 3 years is the exact point you made. I just want people to understand for a second that, right or wrong, Ripple chose to disrupt, if you will, a half-century old legacy banking system that's built on immediate friction fees, right? You just talked about that intermediary takes a big slice sometimes. So if you're the MoneyGram, anyone that sent money through MoneyGram or Western Union, you know that you're paying somewhere between 9 and 15% sometimes. If you want to send someone $200 and it's going to cost you 20, that's $20 that they could use. And so Ripple chose to say, hey, we're going to disrupt this, and we're going to show you a system that takes away all those immediate fees. Bankers aren't excited for that, right? When they see that they're going to lose that fee structure built on friction, and you're going to take away that friction, they're not all too excited sometimes. And some would argue that because of that disruption, this case got filed the way it did. You know what I mean?
Yeah. We're in the middle of a very long tail revolution in terms of how this technology is going to disrupt and change the global financial services system. And I have no doubt it eventually will change, but it requires an institutional reshuffling, and that is not something that happens overnight. Because Bank of America's got to figure out how to tweak and change its business model to accommodate that new world. And so with every other big financial institution, and these are battleships, man, they don't turn on a dime like Ripple. Ripple's a agile, tech startup,
Right.
but they're dealing with behemoths.
Absolutely. And trying to disrupt arguably the most powerful industry in the world,
Yeah.
Last time I checked, Goldman Sachs, JP Morgan, Bank of America, they're pretty powerful and influential people.
Yes, sir. Well, there are questions, loads of questions from the audience. So I'm going to ask Ray to parse through those and maybe, direct the most relevant ones to you, John.
Okay.
There are a slew of questions. So thank you all for submitting and participating your questions. I greatly appreciate it. I'm going to start rattling through these.
Okay.
Let's see here. Johanna, just to answer this question, let me just be transparent. What's the reason for the recent significant drop in the Ripple XRP coin? That's out of our peer view of linqto's. But
the only thing I would say to that, Ray, is what I've said before is, where Bitcoin goes, the altcoin goes for now. That's my answer.
Yeah. If I can add a few words to that, because I'm sure everybody that's a crypto investor is a little bit panicked. I mean, I looked at, the market earlier this morning, and I was astonished at how much it's dropped in the last 48 hours alone, right? It's across all coins. It's not just XRP. But here's one thing I'd like for people to understand and step back, so that they don't panic too much, seeing the tickers move into the reds as quickly as they have across all coins in crypto. There's been a fundamental shift in the crypto market, and specifically in the form of a much greater degree of institutional participation than the last bull market, right? The difficulty is that institutional participation is still in transition. And by that specifically, what I mean is that a lot of institutions that have decided to enter into crypto investing are still, largely for regulatory reasons, afraid to make investments that actually involve them holding the coin, right? And so a lot of the institutional participation, most of it by dollar volume, is actually in the form of derivatives. So these are basically options and futures, right? Highly leveraged instruments. What happens in a bull run like the one we saw is that these institutions were writing massive amounts of call options to ride that upward trend in price. They were writing they were buying lots of call options. They were buying lots of futures, expecting prices would rise above those futures and options contract prices. When the market reversed, all of a sudden we had billions of dollars in out-of-money options and futures. So the guys on the other side of that trade had to hedge the writing of the calls and the writing of the futures by being long the crypto. But once those contracts expired out of money, they were sitting on a lot of crypto they didn't need to deliver anymore. And so they simply dumped everything because they didn't need that crypto to hedge. And that's the reason why you have this accelerated just selling and therefore decline in prices. That's all going to wash out and stabilize. And then we're going to get the real cash market coming back. So structurally, it just points to one of the deficiencies in the market where so much of the volume right now is leverage. It's not in cash crypto. It's in the form of these derivative instruments that have a disproportionate impact when the market is coming up quickly and coming down quickly, right? But so don't panic. I think it's not the fundamentals. It's a lot of these technical things that's affecting liquidity flows in the market.
The only thing I would add is that some people who are very much more knowledgeable than me believe that this is actually needed before we see the return of a real bull market, and that leverage needs to get wiped out. I don't know if that's true or not. I'm just reporting what some people that I respect say. Hey, they haven't lost their bull case. They're like, hey, this is normally what happens or precedes the next run. So.
Completely. The bull case is really simple because it's not about the coin per se. It's about the underlying blockchain technology on which the coins sit. So if you have viable utility tokens that are powering real world use cases that have long-term value, in the long term, you're good.
Yeah.
I mean, it's as simple as that.
Yeah. It's not fun to watch all that red. I'm with you.
No.
I'm a crypto holder. I see my own account, depreciate. It's not fun, but
I hear you. Yeah.
So hang in there. I'm with you. Hang in there. It's all going to turn around.
Hey guys, I brought over Team Apollo member Rob Cunningham up to the panelist section as Rob had a question, and being the fact that Rob is very vocal in Twitter Spaces with the Cool Show, I thought there's no better man to bring up on stage with us. So Rob, the stage is yours, sir. If you've got any questions, please fire away.
Oh, thank you, Ray. Appreciate it, John. Great to see you again. And Joe.
Great to see you, Rob.
Hey, Rob. Good to see you, man.
John, I want to ask you kind of a philosophical question. We've all seen the early videos of Ripple talking about, what's the total addressable market, all the money, right? And so when you want to follow the money and figure out what's all this narrative, this attack on Ripple and what they're really afraid of, what the banking incumbency that's had basically unfettered total control and dominion over the money and the monetary system for 50 years, what is it that they really don't want? Is it the technology? Is it the loss of control? I mean, it seems like they've had total narrative control, and the thing they're scared most of is the decentralization that they have to let go of, and the transparency that allows, if you will, we the people to compare the narratives we've been fed forever with the truth of what's happening in the financial world, the accounting, the openness, the transparency, the books, the record keeping, the cost, the fees, the 16 sets of, where's all the money going that every single person puts their finger on. The thing that I believe is fear and loathing, John, is decentralization and transparency. And that's why we're seeing chaos the world over, lawfare, and just absolute ridiculousness. That's just my take. What do you think?
Well, I think you answered it when you say what is the biggest fear? Control, transparency. If you're an incumbent and you're in control of the system and you don't have to be transparent, there's going to be an inherent resistance. And that's why you have people that are able to predict. First they laugh at you or ignore you, laugh at you, then ignore you, then they fight you. They even send the regulators to sue you and all that. And then eventually they say, okay, we have to accept it. I've been someone who has said, and I've said this on Fox Business a couple of times, that I believe that at some point the incumbents decided crypto, blockchain, not going away. So let's crush it as much as we can so that the incumbents can come in. And we're seeing the Fidelities, well, they've been there a while, but the BlackRocks, the NASDAQ's going to do custody. All of a sudden, I mean, think about when you have the chairman of the SEC saying that crypto folks are fraudsters, scammers, con artists, and hucksters. But is Larry Fink a huckster, right? A scammer? I mean, I'm just saying, is Fidelity, Charles Schwab? I mean, you're talking about the biggest names that have been in control are now, in the last couple of years, been getting more and more involved in this technology. And so, but I think you answered your question as far as what do they fear the most? It would be the loss of control and the fact that that it's going to have to be more transparent as we move forward, hopefully.
Well, John, really, I agree. I think we're all on the same page here. So really the kind of war that we're in right now is a narrative war, right? And they're throwing everything they have at it, from lawfare to scare tactics to false flags to diversions to getting in bed with anybody and saying anything. And just, it's a perversion of the narrative. And I think, to your point, Nick, the video that you kind of pointed us to on Ripple's website, we've got to get back as people that believe in this technology and the transformative nature. We've got to get back to what is the purpose of Ripple? What does XRP do? What's in it for humanity? What is the story, instead of being in the technical weeds and talking about side chains and all the stuff that we geek out over? We have got to become an army, because if we're in a narrative war, our job, one, is to bring more people to the war and teach them why this transformative technology is so critical to mankind, to level the playing field, right? To bring in 2 billion more people, to lower the cost, to bring in transparency and accountability. Right now, they don't like to be held accountable. We're the useless eaters. They're the bosses. We should sit down and shut up and follow their rules. That whole system's being turned upside down. So we can't get lost or look like we just care about money and getting rich. We need to sell the why.
Mhm.
Yeah.
Thank you for that.
That's so true. That's so true, Rob. And the promise of blockchain technology was precisely all the things you pointed out from a philosophical standpoint, right? That's why it attracted so many adherents at that particular time, when it became clear to millions and billions of people around the world that the existing institutional systems are flawed. And that was the great financial crisis that nearly took down the whole global financial system. I'd like to also suggest another way of looking at this, which is that what that crisis showed are a lot of the elements that come up in fragility theory, right? So there's a way of looking at systems, whether they're computing systems, biological systems, economic systems, that basically define fragility as largely having to do with how many points of failure there are in a given system. As if you move evolutionary and economic and computer systems to modes where the points of failure are concentrated and singular, you create massive amounts of fragility. And this is what's happened in the financial economic system. We have ever increasing levels of concentration, right, of risk, and fewer and bigger banks. That's going to blow up on us, right? So the thing about blockchain is that it moves us in the opposite anti-fragile direction by distributing risk and distributing power across lots and lots of decentralized nodes. So from an anti-fragile standpoint, that is the perfect way of organizing economic and biological and, computing systems. And that's the other argument for wanting to move things in that direction. We're moving to systems that will, in the long run, be a lot more stable and a lot less fragile.
Thank you for that, Joe. And Rob, thank you for coming up and joining us on stage, sir. I'm going to go ahead and change it back to attendee and then address with the few minutes remaining of today's fireside chat. Still have plenty of questions, so I'm going to cherry pick a couple more. Let's see here. From another TA member, Yassine Mobarek, who I believe may still be traveling on the other side of the world. So thank you again for joining in and tuning in, Yassine. And again, Yassine and Rob, thank you for entrusting linqto with your investments. But a question from Yassine: will the chance for settlement, and this is to you, John, will the chance for a settlement go up when Judge Torres denies the SEC's interlocutory appeal request?
Yeah, listen, here's the one thing that I can tell you the SEC does not want to do. The SEC does not want to engage in a multiple week or month trial, next year with these two executives, because, like I said, imagine the Ripple's lawyers calling Bill Hinman to the stand, calling other folks that work at the SEC to the stand. And so I think that the chances increase, but it all depends on what their end goal is with the Coinbase litigation, and so that if they never sued Coinbase and were going down that road, I would be much more inclined to think that a settlement can happen. But at this point, if I'm advising Ripple, what is the SEC going to give me that Judge Torres didn't already give me? Like, they have to give me something other than saving me attorney's fees to try the case. Because I think Ripple's lawyers, I think Brad and Chris should feel confident that the SEC is going to have a difficult time. So I don't see Ripple agreeing to a settlement unless there is like a huge agreement on, the fee that Ripple would pay, the fine. Right now the fine is arguably $750 million. But what you're going to see after the appeal is they're going to go into the penalty phase. Sort of what happened in the library case, where there was a decision and then they went to a penalty phase to find out what's the appropriate fee. And for example, with disgorgement, a company is allowed to deduct all of their legitimate business expenses, employee salaries, bonuses, travel expenses, whatever, marketing, all those things. And so there would be an intense negotiation on that. Obviously, $750 million is a lot of money, but I don't think Ripple would ever end up ultimately having to pay that, because in the penalty phase, they'll be able to prove, well, wait a minute, some of those sales were ODL sales where we didn't actually necessarily make money, there weren't profit, whatever. And so I don't see a settlement happening, but it does increase once the judge denies the appeal.
Thank you for that, John. I know you're a busy man, sir. Same with everyone on the panel here. So there's still plenty of questions remaining, but I do see a theme of questions, and they're actually relative to linqto, which I would love to direct to you, Joe, if possible. Another question I'm going to blend these from Patricia to, let's see here, another one from Johanna Branson, but can you describe in short the linqto's global expansion strategy? Any wins and losses, your expectation, timing to potential IPO, any updates on the platform? Joe, if you don't mind leaning in and providing some insights on linqto, sir.
Yeah, we're having another record growth year, guys, the platform today is 200,000 plus users. Total assets on the platform approaching 260 million. We are one of the few firms in the private market space that has managed to not only sustain growth during the bear market of 22 and 23, but also have growth with with very, very strong cash flow and very strong profitability. As a result of that, I think we kind of stand out, and suffice it to say that we've had a whole bunch of unsolicited interest from investment banks that underwrite IPOs to private equity, venture capital funds that invest in startup companies like us, to SPACs that are looking to merge with upcoming companies, and that's all I can say. We will, we look at all of those things and discuss them with our board. So stay tuned.
Very exciting. Thank you very much, Joe, for leaning in on that. There's a number of questions remaining. Unfortunately, can't get to all of them. So what I promise is to respond back to each of them with a follow-up response via email. So thank you all for participating today. With you guys still on the call, is there any closing remarks from starting with you, John, before we part ways here, sir?
Yeah, the only thing I would say is I believe at the beginning of your introduction, Ray, you said that your efforts matter, your opinion matters, and that's been proven. I want to make sure everyone knows that the XRP holder affidavits were cited by the judge in her decision, where on programmatic sales, what mattered to us, the exchange sales. If you go to that page where she cites, 1-831-1-831-26, that 3,600 XRP holder affidavits that she's citing. And the other thing is that there's a footnote in the library case where Naomi Brockwell, she said, John, okay, go in there and argue. And that's where the judge said that he would agree that to make it clear that his ruling against library didn't apply to secondary market. Now, ultimately, the Connecticut judge didn't, or the New Hampshire judge didn't follow through with his promise. But the point I'm making is that Judge Torres cited that. And those two instances that result in her decision are individual holders speaking up and not being afraid to be heard. And I just want to make sure people know that and appreciate that. And they take some pride in the fact that they spoke up and they were heard and they actually made a difference. There's over 1 million pages of documents and pages. There were thousands, over 3,000 exhibits. All right. And the judge only cited a couple dozen exhibits in her ruling, and XRP holders was one of them. And that's an extraordinary thing to take away, that when you fight back, it's the right thing to do. And we did. So I want to thank everyone who participated in that, and I want them to be proud of themselves.
Well, thank you for giving us an opportunity to fight right alongside you, John. So thank you very much. Nick, any closing remarks from you, sir?
Well, I'd like to, thanks. I'd like to just thank John for being here and then for everything he's done. That's just amazing what you do each and every day. Part of why I called Joe and said, hey, we should have you back on is